House recording studio, testing the mic, 1, 2, 3. House recording, 1, 2, 3. Tom is banging his balls. Maybe you can. Mic check, mic check, mic check, mic check. Mic check, mic check. Microphone check, stenographer check. Stenographer check, 1, 2, 3, 4, 5. Mic check, mic check. Mic check, mic check, microphone check. Mic check, mic check, mic check. Microphone check. Folks can see it. Mic check, mic check.
Testing the backup digital recorder. Testing the backup digital recorder. Testing to see how it works from here when we are using the backup system and not the main system.
Witness mic check. Witness mic. Mic check. Mic check. Witness mic check. 1, 2, 3. Mic check. Mic check. Mic check. Mic check. Mic check.
Check 1, check 2, microphone check 1, 2, 3, testing 1, 2, 3. Nope, all right.
The Over-Criminalization Task Force hearing will come to order, and without objection, the chair is authorized to declare recesses of the task force at any time. I'll recognize myself for an opening statement. Good morning and welcome to the 5th hearing of the Judiciary Committee's Over-Criminalization Task Force. During its first 6 months, the task force conducted an in-depth evaluation of the over-criminalization problem. We held 4 hearings focusing on the lack of a consistent and adequate mens rea requirement in the federal code and the problems associated with regulatory crime. Earlier this month, the committee took the important step of reauthorizing the task force for an additional 6 months. We intend to conduct hearings on a variety of topics, including penalties, over-federalization, and the perspectives of various executive and judicial agencies. Today's hearing will focus on criminal code reform. The criminal code is a mess. Rather than a well-organized systemic tool for enforcing important federal criminal statutes, the code is riddled with provisions that are outdated, redundant, or simply inconsistent with more recent modifications to reflect today's modern approach to criminal law. This is due, at least in part, to Congress's penchant for legislating in a vacuum, in a politically popular manner, or in a rapid response to a crisis or a national news story, instead of thoughtfully and deliberately. The resulting code is a vast, chaotic, disorganized amalgamation of federal criminal statutes that is difficult to use for practitioners and nearly incomprehensible for the average American. The size and disorganization makes it extraordinarily difficult to ferret out the law applicable to a particular factual situation, which does a great disservice to the public. Because we will be voting at 10:30 this morning, and I doubt anybody is going to come back after the votes, I am going to ask unanimous consent to put the rest of my statement into the record and hope that other members will do the same. And with that, I will recognize the gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Mr. Chairman, a code is defined as a systematic and comprehensive compilation of laws, rules, regulations that are consolidated and classified according to subject matter. What we refer to as our criminal code is anything but systematic. Taking a clue from the chair, we've asked the Congressional Research Service to give us the most accurate and current count of the provisions, criminal provisions in the code. Their initial response is that's too hard to do. We hope to hear from them in the near future. But rather than take time to utilize evidence-based research in drafting criminal law legislation, we've responded in a knee-jerk fashion, charging ahead with failed tough-on-crime legislation in order to appease public opinion by addressing the crime of the day. We failed to use evidence-based approaches to fashion criminal penalties. For example, we frequently use absurd mandatory minimums to address drug laws when we know that evidence has suggested that it is much more effective in treating and prevention than mandatory minimums and long sentences. Mr. Chairman, I look forward to the rest of the testimony, and I'll put the rest of my statement in the record.
With the same hint that Mr. Scott has taken, I will recognize the gentleman from Michigan, Mr. Conyers.
Thank you, Chairman Sensenbrenner, and I too will follow the leads that have been set out for me. I just want to emphasize that we have an explosive growth of the federal criminal code. We've counted 4,450 federal crimes on the books, and this hearing among other things, is to determine how the criminal code should be modernized. And the costs I've detailed here in my opening statement, and I'll make some more comments about it. And I'll put the rest into the record and yield back the balance of my time.
I thank the gentleman. Without objection, all members' opening statements will appear in the record at this point. I will give abbreviated introductions of all of the witnesses, and without objection, the full text will be put in the record at this time. The first witness is Mr. Michael Volkov, who is the CEO of the Volkov Law Group, which has expertise in areas of compliance, internal investigation, and enforcement matter, and an alumnus of the staff of this committee. Ms. Julie Rose O'Sullivan is the Associate Dean for the JD program at Georgetown Law School. She has written many articles and is the leading case book on white-collar crime, and is a recognized expert in both federal sentencing guidelines and white-collar criminal law. Mr. Roger Fairfax, Jr. is professor of law at GW University Law School, where he teaches and writes on criminal law and procedure and criminal justice policy. And finally, Mr. John Klein practices in the law office of John Klein in San Francisco. His practice focuses on federal criminal defense at trial and appellate levels. He has tried criminal cases nationwide and argued before a number of federal courts of appeals and the United States Supreme Court. I thank all of the witnesses for appearing. Without objection, your full statement will appear in the record. The chair would request that witnesses confine their testimony to 5 minutes. You all have experience with red, yellow, and green lights. You know what they mean. And Mr. Volkov, you are first.
Well, thank you, Chair. What?
Microphone?
Oh, I swore I wasn't going to make this problem. It's on. Oh, there it goes. Chairman Sensenbrenner, Ranking Member Scott, Ranking Member Conyers, and other task force members, thank you for the opportunity to appear and testify before the task force. First, let me say it's an honor to return to the committee where I worked on the staff for several years. I am very comfortable with addressing the task force chair as Mr. Chairman. As a matter of fact, he requires that, and I still do that too. It is also an honor to return to the committee to appear before Ranking Member Scott, with whom I worked for many years on important criminal justice issues, debated a lot of issues, and I'm sure the committee and you miss our colleague, Bobby Vassar, who contributed so much to the committee's work. My years on the Judiciary Committee staff were the highlight of my professional career, and I'll always be grateful to all of you for the committee for the opportunity to serve the public. Now I welcome the opportunity to address the task force on the important issue of federal criminal code reform. This is an issue that is near and dear to my heart. Mr. Chairman, you have led the charge on this issue by introducing, over the last 4 years, the Criminal Code Modernization and Simplification Act. Having worked as a staff member on this important legislation, I know the effort that is required to introduce this bill each year. It is a Herculean task. Your work represents an important bipartisan invitation and challenge to enact meaningful criminal code reform. I want to take a moment to commend your former staff director, Phil Kiko, and I'm sure there's no objection to that, hopefully. And
Without objection, so ordered.
And Legislative Counsel Doug Bellis. Oh, he just appeared, Your Honor. And Legislative Counsel Doug Bellis, who both devoted significant time to this effort, as well as your staff in the last 3 congressional sessions. Well, we can all agree on one thing. The federal criminal code, if left unchecked, will continue to resemble the United States tax code. That is not a good thing. In fact, it threatens any hope we have of equal justice. Each year, a new edition of the United States Criminal Code with a new color, or at least portions of it, is delivered to lawyers, congressional staff, and practitioners. Each year, it accretes new crimes, resembling the old Yellow Pages, assuming anyone here remembers those days. I am reminded of one of my favorite scenes from a Marx Brothers movie, Duck Soup, when Groucho Marx is the president of the mythical country Fredonia, and he's given a report by one of his ministers who asks Groucho if he understands the report. Groucho replies, "Of course I understand the report. Why, even a 4-year-old child could understand this report." Groucho looks down at the report, starts to read, and then says, "Run out and get me a 4-year-old child. I can't make head or tail." same can be said about our federal criminal code. No one can make heads or tails of the code except possibly prosecutors, judges, and defense counsel. Our citizens have no idea the scope of federal crimes, nor are they aware of the coverage of specific federal crimes. The federal criminal code is unusable, unwieldy, and a maze of federal criminal offenses, few of which are drafted consistently, and even fewer of which provide clarity to law-abiding citizens. The danger of the federal criminal code is well known to the task force, as reflected in the title and the charter right here, Over-Criminalization. The federal criminal code gives federal prosecutors even more power and discretion to exercise against defendants. It enables them to manipulate the criminal justice system to charge similarly situated defendants with a variety of crimes. Prosecutors can exercise this power without violating the double jeopardy clause of our Constitution. This is inconsistent with our commitment to equal justice. Our federal criminal code needs to reflect three clear principles. First, it must be written clearly. Second, it must be concise with a minimal use of clear and defined terms. And third, it must be accessible. Right now, the federal criminal code sits as a monstrosity that no one has the time or the inclination to tackle, much less understand. The issue of reform is much more serious than references in the criminal provisions to prevent improper use of Smokey Bear, Woody Owl, or protecting the emblem of the Swiss Confederation. As it now stands, the code is littered with criminal offenses that are used in the criminal justice system to obtain desired results without regard to Congress's intent. The Over-Criminalization Task Force is at the right place and at the right time to advance revision of the federal criminal code. I urge you, as a former federal prosecutor and now a defense lawyer and an alum of the staff here, to recommend that the federal criminal code be reviewed and revised with a goal of providing clarity, applying consistent drafting principles, and reducing the number and reach of federal crimes in order to protect our constitutional system of justice and respect federalism. First, let me just go over the principles that should guide any type of reform, and I appreciate the chair's hammering, and I will submit my statement, obviously, for the record.
Without objection, Ms. O'Sullivan.
Mr. Chairman, Ranking Member Scott, and the task force. I'm honored to be invited to speak to you today about a topic about which I've written quite a bit. I feel a little bit like a weekend hacker advising the wizards on their defense. It strikes me as a little presumptuous for an academic to come and tell expert lawmakers how to revise a code. That said, you have invited me, so I'm delighted to participate. All right. Thus far, those of us who've written in this field have witnessed a remarkable phenomenon in Washington. That is the ACLU sitting cheek by jowl with the Federalists and Cato and everybody else. Concerned groups on the left and the right agree that the code is broken and it has to be fixed. I don't think there's a real question about that any longer. The question is what is to be done. I'd imagine that this kumbaya moment is going to be fleeting. I assume it'll break down fairly quickly once we start getting into the specifics of code revision, because the parties that are coming together now actually have very different underlying values. So, for example, the ACLU is principally concerned, as I understand it, with over-incarceration, racial equity, juvenile justice, and overly harsh drug sentencing. By contrast, I think a lot of the conservative groups who've made their voices heard are much more concerned with federalism issues, with the overabundance and vagueness of white-collar offenses, and with the deficiencies in mens rea that permeate the code. What does this mean? Two things. First, I think the actual process, once the actual process of code reform begins, we're going to see a splintering, and the politics are going to become much more contentious. And second, in light of that, although it's arguable, it may be best to take the entire project on at once so that those with different priorities will be forced to negotiate, horse trade, compromise, with the result that we actually get something done. Prior efforts to reform the code ended in frustration, but they eventually bore fruit. I believe that the U.S. Sentencing Commission was created in part because one could not fix the code in the front end, that is, fix the actual code. So the decision was made to rationalize the back end, rationalize the punishment. The issues surrounding sentencing are as contentious, if not more contentious, than formulating a criminal norm. But the Sentencing Commission was very successful in appearing bipartisan and expert. As part of its processes, it regularly called in experts and solicited the views of all stakeholders, and it still does. Many people are unhappy with the guidelines, but that's the nature of the enterprise. We're not going to make everybody happy. For present purposes, what's really important is that the Commission got the job done that Congress, at least at that point, was unable to do, and it got the job done in a credible and expert fashion. With this in mind, I urge lawmakers to create a permanent, expert, bipartisan body, perhaps this one, whose charge it is to overhaul and continuously respond to emerging issues and problems that percolate up from the courts. This type of body is essential to ensure a devotion to this difficult task that otherwise may well ebb and flow with political seasons, the tenure of committed members of Congress, and the like. It would also provide the means by which consultation with all stakeholders and many experts could actually be institutionalized. And this kind of consultation strikes me as absolutely essential to the kind of credibility and viability of a revised code. It would also ensure uniform drafting and consistent use of mens rea terms, and it would allow Congress to remedy much more promptly problems emerging in the application of the statute. For example, this expert body no doubt would have advised Congress to respond sooner to problems with the honest services doctrine than the 20 years it took the Supreme Court to decide that all the people who went, not all, but many of the people who went to jail for 20 years did not in fact commit a crime. Obviously, how such a body is structured, financed, to whom it reports, the weight given its work product, and myriad other issues would have to be resolved consistent with constitutional and practical constraints. But I think that code reform may well continue to be just a fond dream without such a permanent commitment to the code. Thank you.
Thank you very much, Mr. Fairfax.
Chairman Sensenbrenner, Ranking Member Scott, and members of the task force, I thank you for the kind invitation to participate in this hearing on criminal code reform. And at the outset, I'd like to voice my appreciation for the hard work and dedication of this task force, the members of which are exhibiting exactly the kind of leadership and bipartisan cooperation necessary for the improvement of our nation's criminal justice system. I come to this topic as a former federal prosecutor who has handled cases brought under the Federal Criminal Code, and as an attorney who has defended individuals and corporations charged under statutes in the code, and as a legal scholar who has dedicated much of his work to the improvement of our nation's laws and the justice system. And members of this task force have been instrumental in exposing and responding to the deficiencies of the Federal Criminal Code. Of course, Chairman Sensenbrenner has introduced the Criminal Code Modernization and Simplification Act. In addition, Mr. Scott, when he was chairman of the Subcommittee on Crime, Terrorism, and Homeland Security, he held hearings soliciting views and concerns regarding the state of the Federal Criminal Code. And many well-respected commentators have criticized the Federal Criminal Code for its excessive length, lack of organization, redundant provisions, and outdated offenses. There also have been calls for certain substantive changes to the code, such as the bolstering of mens rea requirements, the decriminalization of some regulatory and other offenses, and the reduction in the number of mandatory minimum sentences. And many of these and other critiques are quite persuasive, and there's no doubt that most observers would agree that the Federal Criminal Code is in need of reform. However, before we contemplate how Congress might best streamline, reorganize, refine, and modernize the Federal Criminal Code, it's essential to draw lessons from past efforts. The seeds of serious modern-day efforts at comprehensive code reform, federal code reform, were sown in the 1950s and early 1960s by the American Law Institute's Model Penal Code, which with its technical precision, elegant organization and draftsmanship, and its attention to principles of culpability and mens rea spurred many states to undertake significant revisions of their criminal codes. With the Model Penal Code and President Johnson's 1965 Crime Commission as a backdrop, Congress established in 1966 the National Commission on the Reform of Federal Criminal Laws, commonly known as the Brown Commission. The 1971 final report of the Brown Commission proposed a new federal criminal code, and this proposed code included a general part that set out definitions, defenses, principles for liability, and general standards for the exercise of federal criminal jurisdiction. The proposed code also featured a special part containing a comprehensive collection of all federal felony offenses. Despite the Brown Commission's tremendous efforts over 4 years, however, the proposed comprehensive federal criminal code never was enacted into law, although there were repeated attempts in the House and the Senate over a period of almost 12 years. So it may be time to revisit federal criminal code reform, and to be sure, many of the challenges that face Congress after the Brown Commission remain. Nevertheless, I believe that we do have a meaningful opportunity for reform, because today a strong bipartisan consensus has been developing around the idea that we should be smart on crime. And given the current receptivity to evidence-based innovation in criminal justice policy, the time may be right for reconsideration of federal criminal code reform. I do have a number of suggestions for consideration if Congress were to contemplate embarking on an effort to revise the federal criminal code. The first is the establishment of a new broadly representative commission, much like the Brown Commission, to draft federal criminal code reform legislation or to work with existing legislation like Chairman Sensenbrenner's bill. The second is a partnership with established and respected law reform entities such as the American Law Institute or the ABA Criminal Justice Section, and the utilization of the technical assistance of members of the Legal Academy and experts in the criminal justice policy community. And third, the establishment of a permanent, professionally staffed criminal law revision commission in Congress that can assist members and committees with the technical analysis regarding the question of whether a contemplated new criminal law or penalty is actually needed, and also the design and drafting of criminal statutes so that they are well constructed and fit appropriately within the larger criminal code. I believe that these ideas, derived from the work of individuals who have been involved in criminal code reform efforts for decades, are worthy of consideration. And if the members have questions later, I would be happy to elaborate on any or all of these ideas and discuss how criminal code reform might fit into the larger bipartisan criminal justice reform agenda responsive to concerns about over-criminalization and mass incarceration.
Thank you, Mr. Fairfax. Mr. Klein.
Chairman, Ranking Member Scott, and Mr. Chairman, Ranking Member Scott, and members of the task force, thank you for the opportunity to share my views as a criminal defense lawyer. A comprehensive revision of the Federal Criminal Code should focus on 5 main points: reducing the number of federal crimes, ensuring that the revised code strikes a proper balance between federal and state law enforcement, clearly defining the appropriate levels of mens rea, establishing uniform rules of construction, and revising the overly harsh punishment system. I'll take those in turn. First, reducing the number of federal offenses. The list of federal crimes has grown from a handful in the Crimes Act of 1790 to thousands today. This growth has occurred in part because the country has become more complex, but it also occurs because every time there's a national crisis, the reaction is to enact new federal crimes. The result is a morass of overlapping statutes. For example, there are more than 24 different false statement statutes in Chapter 47 of Title 18. There are 7 different fraud statutes in Chapter 63 of Title 18, and I count 19 different obstruction offenses in Chapter 73 of Title 18. This proliferation of federal offenses has 2 main practical consequences from my perspective. First of all, the sheer number of crimes creates a notice problem. Justice Holmes declared that fair warning should be given to the world in language that the common world will understand, talking about notice of crimes. But with the statutory scheme that now exists, fair warning is a fiction. Second, the existence of multiple federal statutes that address the same conduct encourages federal prosecutors to overcharge. Some prosecutors take advantage of overlapping offenses to charge the same course of conduct in multiple counts under multiple statutes. The result is often juror compromise. Jurors who can't agree unanimously on guilt or innocence decide to split the baby, to convict on some and to acquit on others, thinking that they're giving the defendant a break by doing that. What they can't be told, but the truth is, that a conviction on one count in federal court is typically as bad as a conviction on all counts. So reducing the number of federal crimes will reduce overcharging, it'll reduce juror compromise, and it'll help ensure fairness to defendants. Revising the federal criminal code affords the opportunity to address other troublesome areas as well. I'll just touch briefly on one of those, which is conspiracy. Justice Jackson warned about the elastic, sprawling, and pervasive conspiracy offense. The offense of conspiracy to defraud the United States is especially amorphous. A revision of the code affords an opportunity to think carefully about conspiracy and to focus more clearly on who truly deserves to be caught up in its net. The second principle is restoring the federal and state balance. Our federalist system initially contemplated that the states would have the primary role in law enforcement. Over the last 50 years, however, federal criminal jurisdiction has exploded to the point that almost any culpable conduct can be brought within the federal ambit. As a result, we see, just to cite some examples from my own practice, we see vote buying in local elections charged as federal RICO offenses. We see non-disclosure under state campaign finance laws charged as mail fraud or wire fraud. And we see violations of local anti-patronage laws being charged as federal honest services fraud. And of course, there are drug laws where the gap between federal enforcement and state enforcement seems to grow. Reforming mens rea, I'll just touch on one area there, which is willful blindness. There's a federal doctrine of willful blindness, which is a judge-made notion that allows the awareness of a high probability of a fact and a deliberate effort to avoid knowledge to substitute for actual knowledge, which is the element that Congress has provided. That's a dangerous provision for defendants because it weakens the mens rea requirement, which is often the only element that's disputed in a federal criminal case. Revising the federal criminal code affords an opportunity to take a look at willful blindness and make a reasoned decision whether it should be used or not. The fourth area is uniform rules of construction. I'll touch on one, the rule of lenity. Now it's applied in a sort of haphazard, ad hoc way by courts. A revision of the federal criminal code affords an opportunity to make that a uniform rule of construction so that doubts about the meaning of a federal criminal statute are uniformly resolved in favor of the defendant. That's important to fair notice. It's important to fairness generally. And finally, revision of the code affords an opportunity to fix some of the harsh punishment provisions now, especially mandatory minimums that have resulted in an enormous and unnecessarily large federal prison population. Thank you very much.
Thank you very much, Mr. Klein. The chair will now recognize members under the 5-minute rule, and I'll start by recognizing myself. One of my goals in this effort is to try to avoid the traps of having an omnibus revision of the criminal code becoming a debate on numerous criminal justice policies, from the death penalty to mandatory minimums to disparate sentences and the like. So in order to not to repeat the record of failure, the past attempts to revise the criminal code over almost 50 years, I am trying to have at least the first attempt at this be policy neutral. I'd like each of the 4 witnesses to give us some advice on how to try to keep it policy neutral, because if it isn't, I think this effort will go down in flames just like the previous ones.
Thank you, Chairman Sensenbrenner. I see this as the most important principle, which is to stay policy neutral, because there are so many issues that have to be addressed with regard to drafting, with regard to inconsistencies, with regard to penalties, that we need to get a foundation document that is almost like the beginning of building a house, that is clear and it's done in the right way, with technically making the right choices and consistency. From that point, everybody can then debate the issues. What's the right penalty? Should we have a death penalty? But we first need a document that makes sense. And the way to do that is, and I share the recommendation of some type of body. And I don't want to go, you started the Antitrust Modernization Commission back in 2006 when we did the Judiciary Department of Justice Reauthorization Bill. That would be some model that could work for like rewriting the code in a policy-neutral basis. Just make that their charge and get a group of people together who are experts in the field to do that.
Ms. O'Sullivan.
Thank you for an excellent and challenging question. What I would suggest is that you begin with, I think what Roger mentioned as the general part, which is addressing the sort of default rules for statutory construction, maybe, legislating the rule of lenity, but also providing default provisions for mens rea, definitions of mens rea, definitions of when omissions are actionable or not actionable. So you could deal with a lot of the endemic problems of the code by articulating a general part, much like the ALI's model penal code, that would be sort of neutral because there would be no context. It applies to drug cases, it applies to white collar cases, right? And so people would be forced to deal with these issues in the abstract on a criminal law basis rather than a political or public policy basis.
Thank you. Mr. Fairfax?
I agree with both suggestions, Mr. Chairman, and I would really urge the idea of having a separate entity, a body with broad representation, perhaps undertake a first cut at a lot of these issues. I think it's much better to have things that perhaps don't even seem like they're controversial in the first instance, but that later turn out to be somewhat controversial, taken up by a commission or by a group in the first instance, rather than for the first time in the course of legislative debate. But I also agree with what's been said.
Thank you, Mr. Klein.
Mr. Chairman, I think true policy neutrality is hard to obtain. I think in almost any judgment, for example, about mens rea, there are policy judgments that need to be made. I think the best way to achieve a politically acceptable result is to have the sort of commission that Mr. Fairfax talked about. I'm on the ABA Criminal Justice Standards Committee. We have prosecutors, defense lawyers, judges, stakeholders who meet and try to agree on standards. I think that approach is probably the best way to get to a result that can actually be enacted into legislation.
Thank you very much. I yield back the balance of my time. Gentleman from Virginia, Mr. Scott.
Thank you, Mr. Chairman. Mr. Fairfax, you mentioned a couple of times the idea of being smart on crime. Compared to what we're doing for drug abuse, what would be a smarter approach?
Well, it's interesting. A lot of innovation is taking place right now in the States. I have been involved with the American Bar Association Criminal Justice State Policy Implementation Project. And the goal of that project is to show states how they can enhance public safety, reduce crime and recidivism, enhance justice and fairness, and save taxpayer dollars, which is a win-win-win across the board. And states that have been successful in working in this area have looked at changes to their sentencing policies in the same way that legislation that I know you and Scott have co-sponsored in the Smarter Sentencing Act. And then also with regard to reentry of ex-offenders. Michigan, for example, through their prisoner reentry initiative, has slashed their budget for corrections and has reduced the overall number of prison beds that they need to supply. So I think there are lots of great ideas in the states, and I'm starting to see them come up to the federal level as well.
There have been several mentions of mandatory minimums. How do mandatory minimums comply with a smart on crime approach?
Well, I think that the legislative trends we're seeing right here in Congress, again with the Smarter Sentencing Act, is really starting to take that question head on. I was actually very heartened. A couple of weeks ago, I know you, Mr. Scott, were present at a roundtable at which Attorney General Eric Holder, Senator Mike Lee, Senator Rand Paul, Senator Sheldon Whitehouse participated in a discussion about these very issues, mandatory minimum sentences, and all of the aforementioned individuals have either co-sponsored legislation or supported a new approach to mandatory minimums, and I think that that is the trend that we're seeing.
Mr. Solomon, did you want to comment on that, and also on whether or not, what the value of having all the criminal code in one place, what the value of that would be?
I'd be delighted to. I think mandatory minimums are wasteful and unjust. They do not permit the kind of even rough estimate of culpability that is necessary to a fair justice system. And I think they also target certain populations. In any case, second part of your question was
Putting all the...
what benefits there are. It's not just tidiness, right, that argues for a tight and discrete code. I can tell you that as a former prosecutor, it is almost impossible to figure out the obstruction chapter. It's overlapping, it's confusing, it makes no sense. It also, for example, you can charge the same crime under a 20-year count, or a 10-year count, or a 5-year count, which gives prosecutors a lot of power that can be used for good or ill. And so I think that it's much more efficient. You don't have prosecutors making mistakes. You don't have things being cleaned up on appeal. Everybody knows what the rules are. You have notice, and then you're able, once you have this code, to make thoughtful judgments about relative culpability. So, for example, in my article I talk about these two statutes. One statute is fleeing from an INS checkpoint. The other statute outlaws female genital mutilation. They're both 5-year counts. That makes no sense, right? But you don't know that until you have a code that you're able to sit back, look at the sections, and say, how culpable is this? So, for example, obstructing a judicial proceeding is a 10-year count. Did you know that obstructing a congressional investigation is only 5 years? I don't know why there's a disparity.
I want to get in one more question. Mr. Volkov. Okay, well, I wanted to give you an opportunity to go through your principles that you didn't have an opportunity to do.
Well, actually, that was the first point I wanted to make, was with regard to the principles. And I know I'm preaching to the choir here, but there has to be a single committee in the Congress that supervises, reviews, and legislates with regard to criminal offenses. Right now, we have other committees that put in criminal offenses into the code, and it is an absolute disaster. And we have to fight that on the staff all the time. And it's right now we need to get all of the criminal offenses that are all throughout the code and bring them into Title 18 and let the Judiciary Committee supervise it and monitor it.
Gentleman's time has expired. The chair of the full committee, the gentleman from Virginia, Mr. Goodlatte.
Thank you, Mr. Chairman. Mr. Volkov, I like the way you think about that, and I have a pretty good idea which committee should have that responsibility for all aspects of the criminal code. I'd like to ask all of you to talk a little bit about drawing the line between where something should be civil and regulatory and where it should be a criminal offense before we get into figuring out what kind of consistency we can have with regard to mens rea. I think we also need to think about what kind of consistency we need to have, or can have if possible, between what things should be civil and regulatory and what things should be criminal offenses. So I'll start with you, Mr. Volkov, and we'll go right across. So you can tell me how to draw that line.
Yeah, I think that goes right to the work that you've been doing up to this point, that the task force has been doing, which is we get to criminal offenses versus civil offenses based on the impact or the action, the conduct or the failure to act, and the requisite intent. That's how we do it. We don't say that, for example, something that you have no responsibility for but occurred on your watch or you had nothing to do with it, that you should be criminally punished for it. There are civil obligations that can come up in that context if you have a duty to act. But before we make something criminal, there has to be an important part of conduct that we're trying to protect and prevent, and number two, that there's a culpable state of mind. And you always have to be consistent with that. And what has happened, as you all know from all of your work up to now, is that issue has been diluted. And it's been diluted down to such a point that Congress does need to act in some respect to fix the intent issue.
Thank you. Ms. O'Sullivan?
I very much agree with Mr. Volkov's comments. You'd have to look at the harm, the culpability, right, and the mens rea. I have to say this is a particularly important question in the regulatory sphere. As you know, Congress very frequently delegates the authority to formulate regulations to an agency and then in advance provides that any knowing violation of the future regulations constitutes a crime.
So we're creating a crime without knowing what
Exactly.
crime we're creating.
We don't know what the content yet is. But more seriously, you know, I don't think anybody is going to count the number of criminalized regulatory offenses. I think at last count there were 300,000. And, you know, that strikes me as crazy. Also, the courts have interpreted knowingly violate to mean know that you're doing the conduct that violates the provision, not that you knowingly violated the law, but that you knowingly ship sulfuric acid without the right label on it. And people can go to jail. That's a felony offense. That's a problem. And that language is used, and that Supreme Court interpretation of that language is used consistently across all these regulatory offenses. So that persons who are mixing two types of turpentine or not making scaffolding in compliance with OSHA regulations could actually go to jail. Now, we know they're not all going to do that. We don't have the resources to pursue all those people, but the problem is the prosecutors, and I was one, so I trust them for the most part, but they get to pick and choose. And you obviously have a potential there for arbitrary and discriminatory enforcement. You've almost guaranteed it.
Mr. Fairfax?
Well, I don't have much else to add other than to say that this actually connects to the initial point, which is, you know, what body, perhaps even within Congress, should have responsibility for implementing, for drafting and passing criminal laws. Whether it's an exclusive jurisdiction arrangement or a sequential referral arrangement, as was discussed in the Heritage and NACDL without intent policy paper, or whether it's a criminal law revision commission within Congress, as I had suggested. I think those types of solutions can help to address that problem. You know that.
Thank you. Mr. Klein?
I think part of the problem, part of the reason we're here, is that whenever there's a crisis, the first reaction is to enact new crimes to address the particular problem. And that's what's led to all the overlapping crimes that we have, at least in part. I think the analysis should work the other way. I think the first question should be, is an administrative or a civil penalty provision, something along those lines, sufficient to deal with the problem? And only if it's not, then proceed to look to criminal legislation. So I think the analysis is on its head right now and needs to be reversed.
Thank you, Mr. Klein.
The gentleman from Michigan, Mr. Conyers, the chairman emeritus of the committee.
Thank you, Mr. Chairman. This is one of the more important discussions we've been having on this task force, and I commend the chairman for inviting these witnesses that are here, and I hope that I can work with him on his legislation, which to me presents a few problems that that we will get into at the appropriate time. Let me say that Professor O'Sullivan and anyone else can join in afterward. You talked about creating a standing commission or task force to reform the criminal code all at once so that we can begin this work. And I see that as an enormous challenge in the legislative system in our country. Might you and others comment about who might be on the, what kind of persons would be on this this commission?
Yes, thank you for the question. One concern is constitutional. Obviously, the creation of the Sentencing Commission sparked a great deal of litigation about whether constitutionally you could vest the power to create sentencing in an independent agency. So I'm very aware that the committee would have to confront how much you could actually delegate and the like. I think that you would have to have a situation much like the commission where you have judges, you have practitioners, and you have, well, here, obviously, you would have to have members of Congress who participate. I would see it as a fairly broad-ranging group with a variety of experience and expertise.
Can I comment? I actually, I don't see the commission as being that broad. I think I clearly would not recommend going towards another sentencing commission because we have a commission which is dealing with non-binding type of guidelines these days, and I don't think there's any reason to go to that. I do think, though, an expert group of practitioners, defense counsel, judges, prosecutors, sitting in a room and saying, the last time the code was reviewed, Mr. Gaynor put one woman in a room and had her go through every page until she was finished. 6 months later, she came out with, here's everything that I found in the 1980s. We need a group of practitioners. Just put us in a room and say, get the job done. No elaborate commissions, not a lot of money, and just get a group of people and do the work.
Interesting. Anyone else want to comment? Yes, sir.
I would say that I actually think that the balance of representation we saw on the Brown Commission was relatively well thought out. I would say that there would need to be more representation. I agree with Mr. Volkov that there would need to be more representation from the practitioner community, and particularly from career and political folks at DOJ. Because what happened in the aftermath of the Brown Commission is that there wasn't buy-in from the executive branch, and that it produced an executive bill. And I think the goal is, particularly if you want to pass this in the lifespan of one Congress, is to have one bill from the outset. And I think getting the engagement and the buy-in of all stakeholders early on is essential.
Thank you so much. Let me ask Attorney Klein, do you have any thoughts about how prosecutors overcharge and the consequences of such a practice, even when the jury decides to convict only on a few counts?
I do. Thank you for asking that question. It's a real problem. I understand why prosecutors want to do it. They're advocates and they want to win their case. But what happens is the same course of conduct is charged in a whole series of counts. Jurors are not told the consequences of a partial conviction. They think they're giving the defendant a break or maybe splitting the loaf by convicting on some and acquitting on others. But under the sentencing guidelines and under the sentencing practices generally, a conviction on one count is really no different than a conviction on every count. So the defense lawyer has to pitch a no-hitter, in essence, if he wants to win the case. Jurors don't know that, and the result is compromise verdicts that pose real problems. Let me give you an example of a prosecuting agency that does it what I would say the right way. The Antitrust Division. When they bring a price-fixing case, a Sherman Act case, they typically charge one count, just one count. And so the jury has an up or down decision, guilty or not guilty. That is the fair way to do it, but the multiplication of offenses now makes it very rare that occurs outside the antitrust context.
Thank you very much. Thank you, Mr. Chairman.
The gentleman's time has expired. The gentleman from Alabama, Mr. Backus.
Thank you. Professor O'Sullivan, you had talked about some of us focus on one thing, others focus on other things, and I think that's true. I will tell you, though, that the harsh sentences, I think there's general agreement that some of the longer sentences are actually not working. They're probably causing harm. They're almost institutionalizing or causing young people to become criminals. And that our system is failing. We do get in, I think some of the hard questions are plea bargaining. I've gone back and I've talked to defense attorneys, I've talked to prosecutors. Prosecutors say to me, and I used to be an assistant attorney general, you know, we have to plea bargain, we have to, and if you take this away from us, we're not going to be able to get people to plead. But they're not you know, they are pleading for the wrong reasons. They're pleading not because they think they're guilty a lot of times, because if they plead, it's to 6 months and a misdemeanor sometimes. If they try the case, it can be 5 years or 10 years imprisonment. And Mr. Klein, as he said, there are actually examples of people who are offered 6 months or a year and no time served, who refused to plead because they really thought they were innocent, were indicted on 15 counts, were found innocent on 14 of those, with the offer out there of a year and a day if they pled, and went to jail for 5 years. And the jury, there was a case in Birmingham I'm aware of, because it was widely reported, where the jury came out and congratulated the defendant's family. Yet they convicted him on 1 count, and he went to jail for 5 years. And some of the jury said we had no idea. We thought that was one of the more minor charges. I think a problem, we're talking about discretion, how much discretion to give judges, you know, everything from complete to no discretion. No discretion has been a failure. I think it's how far do we leave it till we dang it. But let me emphasize something else. There's also a problem that we have as members of Congress, and we've dealt with this on the civil and criminal side. We pass a law and then the regulators or the agency decides that they're going to make it a crime. I mean, we pass a statute, and I'm not even sure we have that realization. I was chairman of financial services. We've passed things and suddenly read they're using those in the criminal courts. We never even imagined that we were passing a criminal law. So I think you've got to take some discretion away from the agencies, like the OSHA, EPA.
That's why you have to.
Finally, let me say this: one of the most complex things, and I'm from Congressman from Birmingham, Alabama, so I feel like I'm handling a stick of dynamite.
Because if you say
it's obvious when you look at the numbers, the high incarceration rate for young blacks. It's something, you know, it's kind of difficult for us to talk about. That is a very complex issue. And I don't believe there's an intention with 99% of prosecutors and judges to be racially motivated. I really don't. I think with the cocaine, crack, you know, that obviously resulted in a terrible problem. But if you listed the reasons, there'd probably be 50 reasons why incarceration is higher among young blacks. Even the presence of police. I can drive through my suburban community and not see a police car for, you know, there's no police presence. You can drive through some areas and there's a police car every 2 blocks. Just the high concentration of police officers. The crime, the violent crime in those communities, it's a higher evidence of that. So I don't know how we address that. I know some of it, I think, is we approach it not as a criminal matter, but as more of a educational matter, or a divert some of these cases. But that's something we've got to look at.
The gentleman's time has expired. The gentlewoman from California, Ms. Bass.
Thank you, Mr. Chair, and thank you for your testimony today. It seems like that the panel kind of agrees that the way we should go about this is an outside commission, although I think you were describing a committee inside as well as outside.
No, I actually share the same. Whether you want to call it a commission or whatever, we need to have all the practitioners in the room, and their charge is to come up with a document that makes sense instead of having overlapping crimes, enabling stacking by prosecutors, all of that. We need to have one rational document to work from.
Well, I guess you were saying then on the Judiciary Committee that when other committees pass laws, they should all come through here.
Right. And that is probably one of the most important recommendations I can make, because as a staff member here, we had to go and fight other committees that were legislating crimes, and they really didn't know what they were doing. We, in this committee, is a repository of knowledge, history, expertise that every criminal offense that is enacted in this country should be reviewed by the Judiciary Committee, enacted, and you can have successive referrals if they want to look at it too. But we all spent too much time watching the territory to make sure that things weren't done stupidly by other committees, to be honest with you.
Suggesting members of Congress didn't know what they were doing.
I'm
You don't
telling
need to-
you,
you don't need to
we
you
were
don't
brought
need
in.
to respond to that.
Ms. Best, we were brought into situations where a
You
committee
don't-
would bring to the floor, okay? All of a sudden, on the floor of the House, were 25 criminal offenses being added to the criminal code in different statutes. Mr. Vassar and I had to run immediately to the parliamentarian and say, what is going on? Go to the committee, argue with the committee, and tell that committee to remove the amendment from the floor.
Okay. Okay, let me ask a couple of situations. I really appreciate, Ms. Sullivan, the way you were describing the differences in values and goals coming from two different directions, and I would certainly want to associate myself with the side that's concerned about over-incarceration, especially with the drug laws, especially now in light of drug laws changing, within the states. So when it comes to purposeful mind, I just wanted to ask, in terms of the direction that the committee was going with the draft, how do you think a situation would be viewed? This is hypothetical, although there were a lot of cases, in particular with women who were involved with men, examples of females being a blind mule, not knowing that they were being asked to transport drugs. I don't know if that falls into what you were saying in terms of being willfully blind, I believe is the way you described it. Or a female who might be stuck in an abusive relationship. Right. There's drugs in the house is raided, and she's caught up as well.
Right.
Maybe
that's a difficult thing to legislate. That strikes me as something that is quintessentially a prosecutorial judgment, but it's one that has to be an educated judgment. I'm not sure that the mule problem is restricted to women, although it's certainly a big issue. I actually had a defendant who was 18. He took a gym bag from point A to point B. He had no idea. He probably knew it had drugs in it. He didn't know what type. He didn't know how much. He got $5 for it, and he was looking at 10 years. One thing you could do in the drug area is require proof, provide gradations of offenses, right, by amount and type, and require the person to know what type of drug they're carrying and approximate quantities. Because right now, people get sentenced for whatever type or quantity actually exists, and they don't have to know how much. But it's relevant to culpability. May I just add one thing to what Mr. Volkov said? As far as the commission, I think this committee is really busy. I assume that you are already fully tasked. So that's one of the reasons I proposed. I didn't necessarily mean a totally independent committee, more of a commission that is sort of advisory to you all. So, for example, if the SEC issues regulations, before you vote to criminalize them, that commission would review them, so you don't have to review all that stuff, right? And advise you on what they think is appropriate. It would be helping this group do what they needed to do, because what we're all proposing that you do is probably the work of 20 people. forever.
Gentlewoman's time has expired. The gentleman from Texas, Mr. Gomert.
Thank you, Mr. Chairman, and thank each of you for being here and for your insights. Mandatory minimums have been obviously quite controversial over the years. When I was a judge, district judge handling state felonies, I had absolutely no problem with being given a wide range of punishment and let me have the discretion to consider all the factors and set a punishment within that range. But I get the impression that if we completely eliminate mandatory minimums, that means the range will always be from no punishment whatsoever to whatever cap we want to put on them. Are any of you advocating that for everything that Congress makes a crime, there should be the possibility of absolutely no punishment whatsoever? Or is it okay to have a range and give judges that discretion?
I'll be glad to start. I think mandatory minimums are a bad idea, pretty much across the board.
Well, my question was about having a range, because when we talk about mandatory minimums, that may completely eliminate having anything as a bottom for a range. So my question is, so we don't get into, well, what does he really mean by mandatory minimums? Do you have a problem with a range being set by Congress and giving the judge discretion within that range? Or is it your adamant contention that there should never be a crime which the least punishment is not nothing? No punishment whatsoever. You want that as a possibility in every single crime. Is that correct?
I think it is. And I say that because...
So every state that has ranges of punishment, like in Texas, 3rd degree 2 to 10, 2nd degree 2 to 20, 1st degree 5 to 99 years or life. Texas is completely wrong in having that minimum of 2 or 5 years. That's your contention.
Well, I hesitate to say that Texas is wrong about anything. I'm a Texas law graduate.
Yeah.
But I think, let me say this. I think that federal judges in the pre-guidelines era and since the guidelines became advisory have demonstrated that they have the ability to impose rational and fair sentences without mandatory minimums.
Absolutely, most of them do.
I think, you know, I've
most
disagreed
of
with,
them do.
with plenty of sentences. But most federal offenses don't carry mandatory minimums, and you don't see very many serious offenders getting away with nothing.
Yeah, but you get into the range, and I remember when the Sentencing Commission came in, federal judges were absolutely livid that their discretion was being hampered like that. And then I was shocked 10 years later to find they kind of like not having, many of them like not having to make the tough calls, and it narrowed their decisions and made sentencing so much easier. I was shocked.
I think where the guidelines stand now, which is advisory, a factor to be considered but not mandatory, I think federal judges, I'm guessing, find those to be of real value.
May I add something?
Yes.
I'm a fan of the mandatory guidelines. I actually wrote probably the only article defending the guidelines. I don't think judges are born with, you know, some wisdom that the rest of us do not possess. I think that the evidence of racial and gender and other really unacceptable disparities that existed prior to the guidelines really were shocking. And actually, if you look at the statistics since the guidelines have become advisory.
My time's about to expire, and I want to ask one other thing very quickly. With regard to regulations, I appreciate what you say. I can't think of a regulation that I think we ought to make a crime without Congress ever considering them. Don't you think there should be no regulation ever being a crime without Congress actually voting to make it a crime? Anybody disagree?
Agree.
And if we make it a requirement that any bill that has a criminal penalty has to come through judiciary, I think that would take off a lot. A bipartisan problem has been both sides of the aisle when we want to show we're really tough on something, then throw a criminal penalty, and it has resulted in vast injustice. And I appreciate all of you bringing that forward. Thank you.
Well, now we found where there's policy agreement, so let's keep on with this roll. Gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Chairman. I do thank you for this, putting this together. I don't necessarily agree with the concept that we couldn't agree, and I may be wrong. Most of y'all have been here a lot longer than me. But I think what the ACLU is interested in, and what I think was maybe Professor O'Sullivan said, what the Republicans are looking, that we could all agree on it, that there's a lot of white-collar crime that shouldn't be necessarily penalized as it is, and there's a bunch of people being put away for drugs and other that shouldn't be either. And we all value liberty. That's one thing we can come together on. And taking somebody's liberty is a serious offense, and it's a costly offense, $30,000 a year. So I think we can really, I think we could work together on the policy. Professor Fairfax, you're familiar with the controlled substances schedules, I presume. Do you think they make sense?
Well, I think that as part of the project of looking at the Federal Criminal Code, a reconsideration of the controlled substances schedules would be in order. But I think that raises one of the points made earlier, that we really need to rely on expertise, right? And we need to supply to the committee in the Congress.
But you think there are problems with the controlled substances chart, or do you think it's all logical and
Well, not necessarily all logical, so I think that there can be differences of opinion with regard to the schedules.
do you think marijuana should be in the same class as heroin?
Look, my mother's a pharmacist and has much greater expertise, and I've never used either substance, but I can tell you.
You don't have to use the substance.
I know, but so again,
you probably know some people have used one of the substances more than the other.
But I do think that a rational approach to making gradations among the various controlled substances and determining which substances even belong on the schedule should be part of the conversation. Yes,
Professor Klein, Mr. Klein, Attorney Klein, do you have a thought about it?
First, I want to ask for immunity for Mr. Fairfax.
Don't need it.
I think the drug laws are a mess, partly because of the substantive provisions and the way different substances have been lumped in together, largely because of the mandatory minimums, which just produce these ridiculously harsh sentences and distort the whole rest of the system. Where there was discussion about plea bargaining. When a prosecutor has a mandatory minimum in his back pocket, the plea bargaining is going to take a much different form than when he doesn't, and it's going to produce, in many cases, an unjust result.
And Professor O'Sullivan, you said that you're one of the rare people that support the guidelines, and I'm against any kind of racial, ethnic, blah, blah, blah. But isn't the effect of that there's now injustice for all rather than just for most?
I don't actually think so. I think if, yes, they're too harsh, but they're too harsh because the statutory maximum, they're built on the statutory maximum that Congress set. I'm not accusing you, but I think if Congress decided to scale down the penalties, there's nothing inevitable about the amount of time that the guidelines provide for. What I like is a structure, that there is a guaranteed set of considerations that we view as necessary to a particular sentence. It's relevant how much loss there is for fraud. And I just think judges aren't necessarily, we're all human. And you used to be, and it's now today true, that if you walked into courtroom A and this judge thought antitrust was terrible, you could get 20 years. If you walk into courtroom B and you think, this judge doesn't have a problem with it, you could get probation. And it's only subject
But
to
as you said, we're all human, and every case has individual factors. Yeah. What if one person had a certain drug, marijuana,
right,
and the second person had it, and they both possessed it in the same quantity, but one person had it because their spouse was dying, and the state hadn't allowed medical marijuana, but the spouse needed it and wanted it, and the other was doing it because it made their dinner better.
Right. were
Don't
two
you think
ways-
the judge should be able to distinguish in those
Sure.
cases?
And there were two ways you could do it under the guidelines. You could do it by looking at where within the range you should sentence people, and you could depart. And the original contemplation of the guidelines was that departures would be freely given based on offender circumstances, because offender circumstances could not be reduced to formulas the way.
Let me go to your more favorite subject. You wrote about honest services. I have to admit I haven't read your law review article, which maybe I should. Do you give a proposed statute to cure the problem with honest services there?
No.
Thank you.
The
You should
gentleman's
have, yes.
time has expired. The gentleman from Idaho, Mr. Labrador.
Thank you very much for being here today, and Mr. Chairman, thank you again for this, I think, very important committee. It's one of my favorite things that I'm doing here in Congress. But Justice Scalia said a few years ago that maybe we should take more cases to trial. That one of the problems with our criminal system is that we don't have enough incentive to go to trial. And I believe as a conservative that what he was talking about is, I think what Mr. Klein said, or what somebody said, that liberty should be a very difficult thing to take away from an individual. We didn't create, our Constitution was not contemplating a bunch of people in prison. Our Constitution, our founding fathers were contemplating a very difficult time for the state to take somebody's liberty away. So as we're contemplating redoing the criminal code and all those things, how much should we consider the fact that it should actually be more difficult to try cases, not easier to put people in prison?
Well, I think that you're getting at a very big point. Remember this, only 7% of the of the federal cases go to trial. 93% end up in a plea bargain. What is the best tactic the prosecutors have? I've been at meetings. I was a prosecutor for 20 years. It's called stacking. You take the crime, you put as many offenses into it as you can, and you stack it up. I've had people and prosecutors tell me straight up, when I was working up here on the committee, I'd say, why do we have this 18 U.S.C. 371 conspiracy, right? It's a 5-year maximum. They said, don't ever take that away. I stack it up and I use it for plea bargaining leverage so that I can take a case, and if I want to say, instead of charging a 20-year offense, a 10-year offense, and making somebody plead to it, I'll say, you know what, your circumstances are not so bad. I'll give you this 5-year offense. They are dispensing justice, not the judge, in that circumstance. And I don't think that this committee or Congress ever thought that that's the way this system was going to work.
So I would take other comments from the rest of the panelists.
I'm happy to address that. There are so few trials in the federal system these days because the prosecutor holds all the cards. The defense knows that. And so the plea bargaining process is a very imbalanced procedure. I'm not saying do away with plea bargaining. I think it's always going to have
Correct.
an important role. But when you've got mandatory minimum sentences, you've got a multiplicity of charges that can be brought against the defendant. You've got forfeitures, often mandatory, that can ruin somebody financially. You've got extremely harsh sentences. You've got vague doctrines like willful blindness that increase the chances of conviction. When that's the arena and a defendant is looking at a choice between pleading guilty, even if he thinks he's not, and getting, say, 2 or 3 years, and risking going to trial and perhaps getting 20 years and a multi-million-dollar forfeiture, many defendants are going to decide to cut their losses. I think to have more trials, many different interrelated aspects of the federal system need to change in the direction of fairness.
I just bring one other point up because I do white collar. I can't remember the last time a corporation went to trial because it is literally impossible for corporations to resist prosecutors these days because of the fine market value problems, all kinds of different kinds of penalties that are applicable to corporations, including debarment and suspension from government contracting or delicensing like Arthur Andersen. So I can tell you that the accepted wisdom in the defense bar is don't even think about resisting a government overture for a plea in a corporate context. And now the government is just going with what are called DPs. They're not even resolving these cases criminally because that's too difficult, so they just, the Department of Justice reaches a civil resolution.
Thank you. Just for the committee, I just think that's something that we should think, especially on our side of the aisle. As conservatives, I think we should be very concerned about the state having so much power that criminal defense attorneys are afraid to go to trial because they know that actually they take more risk going to trial than defending liberty and property and the things that the government should not easily take away from defendants. But thank you very much. I yield back my time.
Excuse me. I'm told that we will be voting between 10:20 and 10:30. Excuse me again. Gentleman from Georgia, Mr. Johnson.
Thank you. It's not so much the sheer volume of criminal laws on the books and how they are apportioned among the various titles of the U.S. Code. It's really a matter of what is the impact of over-criminalization on society. And I think that from the standpoint of how the committee should approach this issue, I think we should do it in a piecemeal fashion as opposed to an overall solution, because it will simply take too much time to get at the worst aspects of over-criminalization. And in my mind, it has to do with the realm of drug prosecutions. And to piggyback on one of the issues that Mr. Labrador raised, the defendant's ability to take a case to trial. Anytime you can get a 2 to 3% base offense, or excuse me, offense level downward departure for acceptance of responsibility, then it means that if you go to trial, then you are going to be deprived of that base of that downward departure. And in fact, you would probably end up at the top end if you dare to go to trial and then testify. So you actually get punished for having a trial and taking the stand and testifying. You may do so because you feel like you're not guilty, but you end up getting punished on top of the base offense level and whatever criminal history that you may or may not have. You're going to get punished for going to trial. So that's one thing that I think we can do pretty easily to address Mr. Labrador's concern. But when it comes to the overall sentencing guideline concept, what we have is the transfer of discretion from the judge in terms of disposition to the prosecutor in terms of charging. So a prosecutor can decide to charge a person with a crime that has a base offense level higher than perhaps one that would be better suited for the conduct alleged. And so with that prosecutorial decision having been made, then it limits the judge in terms of how to best dispose of the case, taking into mind the crime itself, the condition of the victims, the status of the defendant, or prior criminal history, those kinds of things. And I think that we can get to those kinds of issues and address the problem that President Obama highlighted yesterday with his call for this my brother's keeper concept that would keep so many young black males, would really enhance their ability to become first-class citizens of society as opposed to this
under this second-class citizenship, which some call Jim Crow. Would anyone comment on that?
Thank you, Mr. Johnson. You know, your comments raise a couple of points. I mean, one is the issue of collateral consequences. And, you know, that's a significant issue, and it relates to what Mr. Cohen and I were discussing and what Mr. Backus alluded to in his earlier comments. The impact of collateral consequences, particularly on those who were convicted of lower-level nonviolent drug offenses, is just tremendous. And there's a project underway right now under the auspices of the Department of Justice and being conducted by the American Bar Association to essentially catalog all of the collateral consequences in jurisdictions around the country so that practitioners and policymakers and lawmakers can understand the implications of the criminalization that they engage in when they make these criminal laws.
Gentleman's time has expired, and last but not least, the gentleman from New York, Mr. Jeffries.
Thank you, Mr. Chair, and thank the witnesses for their very thoughtful testimony. It seems that as it relates to the problem of over-criminalization that this task force is encountering, there are potentially three areas of exploration as it relates to the problem that we seek to address. You've got a tremendous explosion of the federal criminal code as it relates to regulatory offenses, as it relates to drug offenses, spanning a wide spectrum. You've got limitations on judicial discretion, perhaps inconsistent with the view of an independent judiciary as a third branch, but co-equal branch of government. And then I think a related issue that some of you have begun to mention and some of my colleagues have talked about during their time is prosecutorial overreach. That third area, prosecutorial overreach, seems to be enhanced by, or made more difficult by, both an explosion of the federal criminal code and a limitation on judicial expression. And so I'd be interested in, perhaps we can start with Mr. Klein. How do we deal with the problem of prosecutorial overreach and the imbalance or the harm that's caused by it, and the imbalance and the threat to liberty when you have an overly aggressive prosecutor taking advantage of the explosion of federal crimes and, in certain instances, the limitation of judicial discretion?
Let me start by distinguishing between prosecutorial misconduct and prosecutorial overreach. Misconduct is, for example, the failure to turn over exculpatory information, improper comments in closing argument, that kind of thing. And that's, I take it that's not what you're talking about. What you're talking about, I think, is prosecutors as advocates using the tools they have to extort, I use that word advisedly, harsh plea agreements, to coerce defendants into not going to trial. I don't view that necessarily as anything bad on the part of prosecutors. They're advocates. They want to win their cases, and they use the tools available to them. The key is many of those tools I view as unfair. Mandatory minimums are a perfect example, but there are others as well. The whole doctrine of willful blindness, some aspects of the sentencing guidelines, forfeitures. There are tools prosecutors have that they should not have. If you take those tools away, if you level the playing field, I think you'll see many fewer instances of prosecutorial overreach. Another example, by the way, kind of the theme of this.
I appreciate that distinction. I want to hone in on it for a second, as well as the things that can be done to deal with prosecutorial overreach. As it relates to misconduct, the withholding of exculpatory evidence, for instance, do you think that the law currently has sufficient incentives built into it to punish or deter prosecutorial misconduct?
Absolutely not. I realize that's not the topic of this hearing, but I feel very strongly that discovery reform is necessary. Brady is not working.
Professor O'Sullivan?
I completely agree. There's been scandal after scandal after scandal on the Brady front. I agree with your point about prosecutorial discretion. The difficulty, of course, is that constitutionally it'd be very difficult for Congress to constrain their discretion directly. And that's why we all think code reform is such a good thing, right? Because you can affect their discretion by affecting what tools they have.
Well, if I can make just, yes. The best way to constrain what you see as prosecutorial overreach is to have a clean code, a code that doesn't allow stacking, doesn't allow multiplicity of offenses. One act can result in 10 charges. It shouldn't work that way. You should have the ability to constrain that discretion. One important point, though, when we go back to the guidelines that has not been raised, is that Senator Kennedy was probably the biggest proponent of the guidelines for fear of what he saw was racial discrimination in terms of the sentencing by judges at that time.
Now, what's interesting about that question, I think you're going to have human error and you're going to have human bias in any judicial system. And I think the one thing for us all to explore is whether we think that that human error, human bias is more likely or more dangerous when vested in the prosecutorial area, or whether it's more likely or more dangerous when found in the judicial branch. And I think the founders, at least, built a system in place as it relates to lifetime tenure that was designed to mitigate out at least the possibility of human bias in the judiciary, and that's something that we should all think about, and I yield back.
Gentleman's time has expired. Well, I think that this has been another very interesting hearing that this task force has had with a lot of ideas. I get back to the fact that I think the challenge of getting this done is to have the first step be policy neutral. So with that happy admonition, without objection, the task force is adjourned.
Thanks, great to meet you.
Great to meet you.
Yeah, thanks.